I'm Chris Searcy, and with me is Paul Lipton, and as representatives of the Committee on Professionalism of the Florida Bar and the Family Law Committee, we have the honor today to interview one of the most esteemed members of the Florida Bar, United States Circuit Court of Appeals Judge Rosemary Barkett, on her views and memoirs on professionalism during her experience with the Florida Bar. And Judge Barkett, I'd like to start, just in case there could possibly be someone watching this that doesn't know you, by asking you, if you would, to state your full name and your present position.
Rosemary Barkett, and I am presently a circuit judge on the 11th Circuit Court of Appeals.
When and where were you born?
I was born in Ciudad Victoria, Tamaulipas, Mexico, in 1939, August, either 29th or 30th.
Right.
My mother says the 30th, my birth certificate says the 29th.
When did you come to the United States?
Approximately 5 or so years after I was born, somewhere in 46 or thereabouts.
Where did you grow up?
I grew up here in Miami, as a matter of fact. Went to school a block away.
I'd like to help us get to know you a little bit, to get you to take us through the steps you followed in going from a schoolgirl to a United States Circuit Court of Appeal judge, if you would. And where did you go to high school and college?
Well, I went to high school here in Miami at Notre Dame Academy, which no longer exists, but it was on Northeast 62nd Street. And I went to college in an odd sort of way. I, of course, as you know, entered a convent, and I did my first 2 years in the context of being a Sister of St. Joseph here in Florida. Within our own novitiate, we provided our own education for the first couple of years. And then I was sent to Spring Hill College, Mobile, Alabama, as part of that training.
And was it your idea throughout Spring Hill to go into the convent as opposed to going to law school?
Well, I was already in the convent when they sent me to finish my education at Spring Hill. And I left the convent and then completed my education. I had another semester to go. And my idea at that time was to teach. I was a teacher, and I was going to stay in teaching.
And what took you from teaching to law school?
That's a hard question, Chris. I'm not sure. I think probably intellectual curiosity, a desire to be more independent than teaching gave you the opportunity to be. I love teaching. I still do a lot of it in the judiciary now, and I love teaching as far as the kids were concerned, but wanted to do something different and something more, I guess.
All right. Was there an event or a person that influenced you to take the step and go to law school?
No, not really.
Just gradually evolved?
Just in general, the idea of being a lawyer, the idea of going into law was attractive on a lot of levels for a lot of reasons.
Where did you go to law school?
I went to the University of Florida in Gainesville.
And when you graduated, what did you do?
I went to work for a trial law firm in West Palm Beach, as you know, because you practiced there shortly after I did, or about the same time, with a firm by the name of Farish & Farish. Joe Farish Sr. and Joe Farish Jr. were the founding members of that firm.
Which subsequently became Farish.
Well, we were never, the name of the partnership at the time, through the entire time that I was with it, was Farish & Farish, but different.
And yourself and one of your fellow judges, Hugh Lindsay.
Hugh Lindsay.
Came from that firm.
Yes, as did Judge Jim Downey. Yeah, I don't know.
That's right.
And a lot of other very good lawyers.
What years were you a practicing trial lawyer with the Farish & Farish firm?
I think from the years of 70 through about 78, and then I was a sole practitioner for a year. The firm kind of dissolved, broke up, and Judge Lindsay and Ken Slinkman and myself practiced independently and individually, and Joe and one other partner stayed together.
I can recall coming to Palm Beach County in the early 70s, and while there were other female members of the bar in Palm Beach County, to my recollection, you were the only female lawyer that was going in and trying high-profile jury trials, personal injury trials.
I think that's right. I think I was the only trial lawyer, woman trial lawyer in Palm Beach County at the time.
Can you share with us the professionalism issues that you faced in being in that situation? A pioneer in the sense of being a female lawyer in a courtroom environment that was not used to female lawyers.
It's hard to recollect that long ago, Chris. But my recollection of Palm Beach County at that time, and probably for a significantly long time thereafter, was that it was such a small community. It was, I think I personally did not get a sense of of many of the issues in terms of being a woman and having some negativism attached to that than many other people, women, have felt in other situations, and that felt in Palm Beach, for example. I was with a small personal injury firm, and Joe Farish treated everyone in the firm, in terms of salary, for example, and in terms of trying cases, equally. I have to say, we had, when the firm broke up, there was litigation, as you know, and it was clear throughout the years that he didn't, although there may have been disagreements about issues, there was never a question that the salary was always the same based upon when you came into the firm and how long you had been there, as opposed to any kind of gender issues. And in terms of trying cases, Joe was very much a person who believed in results, and if you were able to successfully try a case, you tried it. We were trying cases, both Ken and Bob Saylor and myself, within 3 or 4 or 5 months from being in the firm. No, we didn't try great cases at that time, but we were actually trying our own cases.
And as I recall, you were very successful at trying them and tried a lot of them.
I tried a lot of them and did fairly well. It was before the times when there were these multi-million-dollar verdicts, so I wasn't that successful, but I like to believe that I did well.
Well, by what were our big verdicts during that time, you were getting more than your fair share of them and doing it frequently.
I'd like to think I did a good job for the firm.
And I think your success led to the opportunity for you to become a circuit judge.
I think so.
And you became the first female circuit judge in Palm Beach County.
I think that's correct. Now, Mary Lupo had preceded me on the bench, but she was in the county court. She, I think, was the first county judge in Palm Beach County, first woman judge in Palm Beach County on the county court.
If you can go back into your mind's eye when you were ready to step into this somewhat unknown, very responsible position in a pioneering role, what was your definition of professionalism or code of professionalism or approach to professionalism that you brought with you to the circuit bench of Palm Beach County?
Well, I think, and as we spoke a little bit earlier, I think what I said at my investiture was that I would like to treat the lawyers and to have the lawyers treat one another the way our parents taught us to deal with my siblings and other family members. And that is, there was always an expectation that you were going to be honest with them, be always courteous, or try to be, have a sense of humor, a lot of compassion, all of which was included in a constant sense of discipline about the requirements to do whatever it is that you were doing well. And I think I used them as an example then, and probably have throughout my life, in terms of gauging one's conduct. They worked exceedingly hard. I think they treated, or tried to treat, most people, or all people, as honestly as they could. But with their expectation of us was that we would be disciplined, that we would do what was expected of us. But they also had a lot of compassion at the same time. And I think that was the overriding sense of how I thought, and still think, people ought to treat one another and treat the jobs that they are doing.
Was it easier to accomplish that than now?
I probably would say yes, because it's easier to be fair and to be compassionate and to be good to the people that you know. And in those days, people knew one another fairly well. It was a small community, a small legal community. People were constantly in contact with one another. The case that you tried today would be over, but you would be trying the same cases with the same lawyers. And therefore, I think it's an easier thing to be respectful, to be careful, to work hard, and to be responsive to the other lawyers. Now you have a tremendously large legal community. I think it's human nature to give in to the temptation to perhaps be cross the line of honesty on occasion, or the line of rudeness, and to be less caring when you don't know the person very well, or you think you're never going to see them again. So I think the numbers have made a difference, and I think we need to step back and examine our conduct all the time in terms of how it's the old golden rule concept that we don't seem to use anymore. Examine our conduct in terms of how we would want to be treated, or how we would want our children treated, and act accordingly. I think that would be a good guiding principle.
And that's sort of the spirit behind the code of professionalism that you have followed?
I think so. Tried to follow.
How long were you on the circuit bench?
Approximately 4.5 years.
And you went from the circuit bench of Palm Beach County to where?
To the District Court of Appeal, the 4th District Court of Appeal, the State Intermediate Appellate Court. Well, not really intermediate. It's a final court of appeal for many things.
Can you share with us the different perspective you got as an appellate judge as opposed to a circuit judge, and the insight or different insight that may have given you into issues of professionalism?
It's judging is judging, and it's a real privilege to have had the opportunity to perceive it from different perspectives. And the appellate perspective is slightly different, maybe even more than slightly different. There is a necessity to establish rules and regulations for broader audience, as it were. You're dealing with a principle as opposed to an individual in a particular case most of the time in the appellate context. Whereas in a circuit court context, you're dealing with individuals in many cases, and you're dealing only with the relationship of those individuals to a particular legal principle, and it gives you the flexibility of sometimes helping people fashion a solution to their legal problem that maybe would not work as a general rule for everybody, but which would work for those two individuals. You don't have that flexibility on the appellate bench. Although I think that we're beginning now to examine mediation in appellate contexts, for example, and other ways which will give you that flexibility.
Right.
Every case that comes up to the appellate court is not or should not be a trend-setting case or a policy-making case, but and ought to be susceptible to resolution in a different way than what you may have to do in an appellate context. That's one thing. The other thing is that you have the benefit of the thinking of other people, which you don't have as a trial judge. And people told me when I was on the trial bench that I wouldn't like that, you have an independence in the circuit court that you do not have in the appellate bench. As a circuit judge, you're the only decision maker. Whatever you say goes until it gets to the appellate court. Whereas on the appeals court, it's a 3-judge panel, as you know. And you are not the end-all and the be-all of in terms of being a decision maker. You must persuade or convince one other member of the panel to agree with you before that becomes the law of that particular case. Contrary to what people thought, I didn't dislike that at all. I liked it very much. I thought it was a fascinating way of resolving issues and a kind of a really neat opportunity to understand things from a different perspective. And it's not things that you think, I mean, if you thought of the other perspective, you would have already thought of it. But I mean, it's something you don't anticipate because you're looking at a case, you can only see it one way, even though you try to examine it from the perspective of the two lawyers' positions in the case. But nonetheless, when another judge then is able to say, well, in response to your analysis, well, but you didn't consider this, or how about this, or I looked at it this way, then you kind of, I mean, it sort of broadens your horizons in a very concrete way that most of us would think would not be possible because we think we've considered everything. So I found that a very healthy, a very interesting, and a very rewarding aspect of practicing law, to have 3 intelligent people, for the most part, analyzing the same problem and looking at it from 3 different perspectives. I just found that a very fulfilling kind of thing, even if you disagreed ultimately.
Yeah.
So I think that's very interesting. From the legal, ethical, professionalism concepts, I found that there too it becomes sometimes too easy to cross the line from advocacy to misrepresentation, when lawyers will misrepresent cases or will reflect that the record is something other than what it is. And you find that very distressing. And it's because they give in to the temptation to be too much of an advocate. You know, lawyers, after all, are dealing only with the facts that were created or established before they ever got to the case. And sometimes it's not facts that you're pleased with as a lawyer, and you want them to be different than they are. And I think sometimes you cross the line, which is unfortunate.
And crossing over that line is then fighting in an unfair way with your adversary, that if you were trying to treat him as you'd want your family member
Exactly.
to be treated, you wouldn't do. You'd fight aggressively with him, but you'd fight fairly with him.
That's right. And you're more than that. You're not only doing a disservice to your adversary, you're doing a disservice to the system. The system has to operate, the adversary system has to operate with the understanding that everybody is being honest and straightforward. There are going to be differences of position and a different view of whatever facts there are, and that's certainly legitimate. But it does a real disservice to the system if you are presenting to the judge a case that doesn't exist or that misrepresents what the facts were below. Aside from all of that, it's also very stupid because judges are not dumb, and they see that eventually, they may not see it at oral argument where they have not read the record, but they will eventually see that there has been a misrepresentation. And of course, then your reputation is ruined in a very dramatic and a very concrete way.
And in a long-lasting.
And in a long-lasting way, that's right. It won't be simply that case where the judge will turn off that lawyer's remaining argument, because he or she knows that this is not true. And so why should I listen to you? Why should I pay attention to the rest of what you've said if I can't trust what you've said? But beyond that, the next time that lawyer comes up, their briefs are going to be scrutinized very carefully. They are not going to be given the benefit of the doubt that another lawyer might be given.
You were on the 4th District Court of Appeal for what years?
About a year and a half.
All right. And were then appointed where?
To the Florida Supreme Court in 1985, Columbus Day.
And as I recall, you were then the first female Florida Supreme Court justice in our history.
Yes, and still was, or still am.
Still am, still are.
Unfortunately, I would like to have that record erased.
And became, at one point, the Chief Justice of the Florida Supreme Court.
Yes.
Can you share with us the difference in perspective that you gained from the highest court in the state versus the
Appellate
direct
court?
appeals court?
Well, there again, it's a broader responsibility, whereas you were in the 4th District Court of Appeals, you were in many instances constrained by law that already existed, and looked at cases from that perspective. Does this fit into this pattern? Does this fit into this other pattern? And tried to sort of fit the pieces of the puzzle, of a puzzle that already existed. On the Supreme Court, you of course have the responsibility of resolving disputes between districts, which means sometimes taking a look at the law not only in terms of the precedent that exists, but the precedent that you are setting, which may be something that is not on the cover of the puzzle, but is going to be eventually. And that puts a different perspective on it. You are analyzing things really from a fresh point of view in many instances. I'm not suggesting that you look at it in a totally fresh way, because you take into account precedent which will impact on how you see or how the law is going to be developed. But nonetheless, you have the authority, you have the duty in many instances, and the responsibility of saying, although this may have been the law, it has developed to a point where that no longer should be the law and this should be the law. You do not have the freedom to do that as an intermediate appellate court. That's one of the major differences, and of course the tremendous difference in terms of your responsibility for the administrative aspects of running the judicial branch of the entire state, which are very significant. An area where there's a lot of ignorance about the administrative responsibilities of the court.
With regard to professionalism, I think sometimes we need it most when we're in the most critical and difficult times.
I think that's right.
I recall a time when, as a Supreme Court justice, there was an effort by some particular special interest groups to campaign against your merit retention election, which many of us thought was very unfair to you, and placed you in a very difficult position as a Supreme Court justice in somehow having to campaign for merit retention against an adversary. And you did it successfully, and you did it very professionally. But could you share with us the professionalism issues that you had to deal with in being the first Supreme Court justice really to have to take on that type of a fight and that type of an issue?
Well, that would almost be the topic of another whole conversation, because I do think I think that there are a lot of issues that need to be addressed in that context by our society, by our state at large. I wasn't the first to have to confront them, because Justice Shaw, the 2 years before that, also had the same, as a matter of fact, the same interest groups, and had to also wage a campaign. So we had it actually twice before. The 2 years prior to that, Justice Ehrlich and Justice Shaw together, was it? Yeah, Justice Shaw, the prior election of Justice Shaw. Also with a different interest group at that point in time, and also had to grapple with the issues that have to be addressed in a campaign. For example, the raising of funds that has to be done if you're going to respond to a campaign to oust you from your seat. I think those are very difficult issues, Chris. Clearly, the only audience for fundraising for a judge is the legal community. And at the same time, it is the legal community that appears before the judges. The judges are caught in a situation where this is the system that has been established by the people of this state. It's not as though you have a choice. One has to respond, and the only way of responding is to conduct a campaign, and the only way to fund a campaign, if you do not have the personal resources or do not wish to use your personal resources for this kind of thing, is to fundraise, and it is only the legal community that has any interest in or any knowledge of the issues involved. I think that's a real problematic question that has to be addressed by the people of Florida. They either need to understand that this is the way it has to be, or they have to find some other way to fund a merit retention campaign if they want to have a merit retention campaign, or an election campaign for the trial judges, because the trial judges are in exactly the same boat. They too have to seek funds from lawyers. That's one of the major issues, I think, that is involved. I hated having to raise money. I, of course, didn't do it directly, but other people did it on my behalf. I'm not so sure that there's a distinction there. I don't like it in either case, but it's something that needs to be done if you're going to be able to get your message across to the people. And the message being the misrepresentation that is occurring by the people who are challenging you, assuming there is a misrepresentation. The other issues involve the fact that you cannot address specific issues beyond your ability to be fair, your ability to be competent, to work hard, to be diligent, to be honest. But you cannot promise anybody anything in the same way that other politicians can and do, and which the people want. I mean, they do not understand. There's a tremendous educational problem with this whole concept of judicial elections. People want you to say, I will do this if I'm a judge, or I will do that. And obviously, number one, you have no control over what is coming before you, which is as it should be. And number two, you obviously cannot prejudge. I mean, it's so antithetical to the concept of judging, but people don't understand that. They do not understand that you obviously cannot prejudge an issue. You don't know what the law is going to be. You don't know what the facts are going to be. And they would not want a judge who had prejudged the case that they were personally involved in. They understand it at that level, but they don't understand it in a broader level. So it's very difficult to campaign, and I, finally got to the point of just saying outright at the very beginning, the only thing I can promise you is that I'll vote against you if you're wrong. but those are some difficult issues. And then, of course, there were issues that are more subtle that came up actually by accident in my campaign, where we released opinions that caused more fuel to the fire, and people actually raised the question of, well, shouldn't you have held that opinion until after the election? Of course not. I mean, that would be not right. That would be unethical. That would be unprofessional and improper. But I can see where you would be, tempted. I mean, I never thought about it, but so I can't take credit for a conscious choice. But I can see that those are issues that would arise in a judicial context.
Can I interrupt for a second?
Yes, please. professionally and with credit to the Supreme Court. And let me interrupt before you get started. Okay, all set? Judge Barkett, in having successfully navigated those treacherous waters of being a Supreme Court justice who's having to respond to a special interest group challenge with frequently confusing and conflicting issues as to duty, what did you fall back on as you went through the unknown issues, the challenges, the crises that allowed you to come through it all so successfully, so professionally, and with credit instead of discredit bestowed on the Supreme Court?
Well, I guess the same things that we've talked about before, the concept that you have to work hard, that you have to try to be as honest as you can, and that you have to, and this was the hardest part, that you have to try to understand that your adversaries have a point of view that they are sincerely espousing, so that you try not to bear grudges or to be upset that they are exercising the right that they have under our system at the present time. Because as we the judges have the obligation and the almost the responsibility of having to respond to it by having to run a campaign and raise money and so forth, they too, by that system, have been given the opportunity to challenge judges, and you have to understand that as well. So I again try to emulate the things that I think I learned at home, that you try to understand that the perspective of the person that is on the other side, as it were, that you work hard and you try to be straightforward and honest and not compromise your position regardless of any possible consequences.
You were appointed from the Florida Supreme Court to where?
To the United States Court of Appeals for the 11th Circuit.
All right. And could you share with us the difference in insight from sitting on a court in which Florida is just one of the 50 states of its jurisdiction?
It's very interesting, and it's very different. It's much, well, you know, I keep saying it is different from what came before, but each of the changes that in position, which I've been privileged to make, has had differences. Here, you have a whole new body of law that was unfamiliar to me. A lot of the things that federal appellate courts deal with, I had not had to deal with as a state judge. Bankruptcy matters, many of the antitrust matters. Although there is concurrent jurisdiction in many issues, really it isn't used in the state courts very much. Much of the Title VII and Civil Rights Act legislation that has resulted in a lot of litigation in the courts was somewhat new to me in terms of deciding issues in cases. So that's been a fascinating kind of experience, trying to learn a new body of law, and it's very challenging and intellectually stimulating to try to understand that. The way of approaching cases is somewhat different. Under federal rules of approaching cases, we dealt in great measure with our Florida constitutional principles, which have developed somewhat differently than the federal constitutional principles. That's different, and of course you're back in a mode of trying to analyze the law that exists in order to apply Supreme Court precedent, as opposed to trying to develop the precedent and see which direction the law should or should not go based upon what went before. So that's different as well. From a personal, somewhat personal point of reference, you of course need not worry about merit retention anymore, since this is a lifetime appointment. And I have to say, I don't think I was ever concerned about it in the state courts I'm just not kind of made that way, but you certainly are conscious of the fact, or people are constantly referring to the fact that, you have a lifetime appointment and therefore need not worry about popular views. I'm not so sure that that's a real change in a subjective way with me, because I don't really think that I worried too much about it before, but nonetheless, that is a difference.
Having taken us through some of the steps of your career, which has been one of the most successful and remarkable of any member of the Florida Bar in our history, if you could speak now to a young lawyer, a Rosemary Barkett or a Chris Searcy or a Paul Lipton that's in their first few years of practice, with regard to professionalism, what advice would you give them?
Well, first of all, I think you're being overly generous about my success. But in terms of what I would try to tell a young lawyer, I think probably the most important thing is to try to make them understand that they do not need to compromise their principles, and that they should never do so. And there's a difference between principles and being stubborn about things that are not principles. I'm not talking about that, but I think that young people seem to believe that getting ahead requires them to bend their principles or give some of them up. And I really and truly do not believe that's true. I think people respect you more for adherence to those principles than changing them as you perceive, or as somebody might perceive they should be changed. I think it is important that they do the kinds of things we talked about, to put themselves in the shoes of the other person and understand where they're coming from, so that they treat them with the respect that is due to everybody, notwithstanding that they may not agree with their position, or that that the adversary is advocating a position which they abhor. That's in our country, everyone has a right to present positions, and one doesn't denigrate the person for advancing them, even though you may want to denigrate the position. And I think that's a distinction that has to be made all the time, and that young people need to understand. It's hard. The other thing is they should understand that sometimes it is going to be hard. It is not easy all the time to do the kinds of things that we all know should be done. It's not. Sometimes you really have a tendency to hate the person that is advancing a position that you find abhorrent, but you need to try to. I think we're never going to get ahead as a society if we don't try to understand that there's a difference between the human dignity that warrants respect, and a position which you might find offensive, and that you should be exceedingly honest. And there is a difference between being an advocate and being dishonest. And you're not responsible for the facts of your case. The facts are the facts, and the client is the one who is responsible for them. Your job is to present them in as best you can in the light that is most favorable, but which is legally plausible to the court. And I think the other thing is you shouldn't take yourself as a lawyer way too seriously. Lawyers have a tendency sometimes to think that their position as lawyers entitles them to something different or more than other people have, and I just do not believe that's true. The only thing that it entitles you to is a responsibility and a duty to adhere to the oath that you take as a lawyer. And although a plumber or an electrician or a teacher or a doctor may not have that responsibility, they have the same responsibility that lawyers have to be competent in their jobs and to give their clients the full measure of what their clients are entitled to in terms of representation. But you oughtn't to have the large ego that sometimes lawyers have about being lawyers. It's what you are as a human being that I think that entitles you to that kind of feeling of pride in doing something well, not your status in the community.
I wanted to let Paul Lipton ask you some questions, so
Okay.
I'm going to be quiet for a moment and let him talk with you.
Thanks, Chris. Just a few questions,
Sure.
Judge. Do you see a difference between the issue of ethics and professionalism? Is there a difference between the two terms?
I think now they have become intertwined in their usage, and generally when people are speaking about one, they are speaking of the other. I think there probably is a difference in the sense that you have some moral responsibilities as a human being that have to be discharged in your position as a lawyer, both in how you treat others and in how you treat your clients. There are additionally, however, certain rules and regulations which have been developed by the profession to which you owe allegiance and a duty to obey, which I'm not so sure have something to do with, for example, some of these moral things that we're talking about. I'm trying to think of an example, but it's
Sometimes
difficult.
there have been issues raised that a lawyer could very well be ethical, and yet the way he or she
unprofessional.
treats someone, setting a hearing when they know the person's out of town, things like that, it may very well be ethical technically, and yet professionally it's tainting everything we are and what we should stand for.
Yeah, I think that's correct, and I guess that's kind of the thing that I was referring to. There's a whole set of rules and regulations that you must comply with to be ethical. But beyond that, there are other things that make you a moral lawyer, which I guess is how you're using the term professional. And I think that all of those things are very true. Those are the kinds of things that we've been talking about. You don't treat people in a way that is maybe technically okay, but morally not very okay at all.
There's a perception, whether it's real or not, that the legal profession is not what it used to be. I don't know, again, if lawyers are under a great deal of attack and the legal system's under a great deal of attack. What are your thoughts about that?
I mean, it's ironic because if you look back throughout the ages in literature, lawyers have been attacked forever. So I'm not sure that I agree that lawyers are any worse today than they were 10 years ago or 50 years ago or 100 years ago. I think that there are many more people in our society and many more lawyers in our society, and that presents a dual problem. One of the problems is that, again, it's easier to treat people that you don't know well with disrespect than it is to treat people that you know well. So when we moved from a small community where everyone knew one another in the legal profession, very similar to what happened in the United States in general when you moved from small communities where neighbors knew one another and helped raise one another's children, and engendered thereby a real sense of respect for one another and a real, how can I put it, a disincentive for children to be bad or for people to I mean, it didn't eliminate it, but it was much less than what we have in a community which exploded and where we had so many people and so many lawyers that maybe it was easier to be less respectful or less honest or cross over the line with people you did not know as well, just as it has been much simpler for children today in large communities to misbehave or to commit crimes against people they don't know.
So that familiarity is important, and
I think it's imperative, and in many ways, to eliminate discrimination in a million contexts, ethnicity and every other way. I think it's important. If you can't get to know people, then what you should do is try to do it mentally in terms of putting yourself in their place and looking at the world from their perspective. And hopefully will make all the difference in the world. That's also not easy to do. I mean, it's hard. I mean, I say that because I know it's hard for me in many instances, and you have to make an effort to put yourself in the position or in the mindset of a judge who is presenting a different view, for example, or a lawyer who is presenting a different view on a case. It's difficult, but we have to keep striving to do that, or we won't ever get better.
I guess this is a question that's a variation on the theme of what Chris asked, but let me ask it anyway because it's been going around in my head. You have been very, very successful. What do you attribute your success to as far as, I know we've talked about the code that you followed. What do you attribute your success to?
I don't know, Paul. I mean, it's really very strange. I honestly don't know myself, because if you were to isolate who I am or what I know, there are so many people who have the same amount of knowledge, the same. I mean, I don't know that I can answer that. You're going to think that
you must have brought something to the profession, to the bench, that people just looked at you, because they do, and they say, this is a person that makes a difference.
Well, probably because of my position. I mean, I don't. But it's very hard for me to say, and I'm not being falsely modest. Believe me, I'm not. But I mean, I truly would love to believe that I'm the best lawyer in Palm Beach County at the time I was appointed to the trial bench, but that's just simply not true. I mean, it's silly. I mean, there were 100 people who could have been appointed to the circuit bench when I was appointed, who were just as competent, just as honest, just as straightforward. I mean, I don't know. I think it's, sometimes I think that there is fate or karma or something that where I was lucky enough to be in the right place at the right time with the right, I like to believe, the right combination of attributes. It is foolish for anybody to believe that, well, I mean, I could turn the tables. Chris, let's just take an example, is a very successful trial lawyer. And I would believe that he would tell you that he lucked into a situation which combined both the luck, the location, and his abilities at any given time. I mean, he could have been born in Montgomery, Alabama, and practiced law in whatever the neighboring small town is that I passed through. And I'm not so sure he'd have the $1 million verdicts that I mean, one likes to think that you'd always rise to the top. I don't know, but I think it's just a combination of things, of being very lucky to be born where I was born, to the parents that I was born to have the siblings that I had, to have the exposure to the schools that I went to as I was growing up, to have the exposure to the convent that I had, to be in a place like Palm Beach where, you know, I loved the people and the community and still consider it, you know, my home as much as I consider Miami my home, to have had a governor at the time, to have had peers that were supportive when my nomination was being considered, to have a governor who was open to the idea that women could do the things that men could do in law. Just a combination of all of those things, and beyond that, I don't know.
If I could break in on, based on something you mentioned at the beginning of that answer, karma, or
God,
come back, or looking back on it, and looking back at the code of professionalism with which you approached things, where you were going to do it straight and honest, and you were going to, even when it wasn't comfortable to do so, try to look at everybody in the system as, if that were my family member, how would I want them to be treated? In looking back on that, don't you think that it's that coming back to you that has
Yes.
caused you to be able to achieve the position that you have, instead of falling into pitfalls that would have kept you from ever getting there?
I think so. I mean, obviously, I think that I think that acting that way has had to have helped. And one thing I will say that you must do to be, or at least that I feel I've done that helped in an unintended way, is you do what you do because it is what is called for that day, not because you intend it to do something for you later on. And that would be the advice that people would say, well, what do I need to do to become a justice on the Florida Supreme Court or whatever, to be successful? And my response to them is, I think probably the thing that helped me the most is that I worked really hard at doing whatever it was that I was doing at the time well. Not because you think, I mean, it never in a million years, I never thought I was going to be a circuit judge. When I was practicing trial, well, if it weren't for Sid Stubbs and Larry Klein coming to me and saying, we think we should have more trial lawyers on the trial bench, and it's time also for a woman to be on the trial bench, you really ought to apply, it would never have occurred to me in a million years.
You were acting without expectation.
Exactly, exactly. And you act you give your all to whatever it is you're doing at the particular time, because that's what you have to do. You have to do the job you're doing well. That will hold you in great stead, no matter what it is that you eventually will move to throughout your lifetime. But there again, it's very hard for me to say that one takes credit for that when one had the background that I had, where you were taught to practice that kind of response. And that's the part that I'm saying. I don't think that I'm not trying to be falsely modest. I'm just saying it's certainly much easier for someone to develop those traits when you've had training to develop them. And if someone doesn't have the training and the benefits that I had when I was growing up, it's a much harder job for them to attain success.
Thank you, Judge.